insurance laws and the regulations, they're confusing. A lot of times policyholders, when they're going through a claims process after a loss, they have a lot of trouble understanding whether or not their insurance company properly denied or in whole or in part their claim. And those questions, when people come to me, when I've had clients come to me, those questions are often, hey, is insurance being fair here? You know, was this really properly denied? Or, you know, was this really the appropriate amount of payment for the loss that I have? Will this put me into my pre-loss condition? You know, I'll have clients that talk to me and say, hey, I've spoke with contractors again and again who, you know, are telling me that the amount insurance has agreed to pay isn't sufficient to cover my loss. And the reason why that happens in quite a few scenarios is because the adjusters that work for the insurance companies are often the ones that are actually writing the estimates for insurance. And these adjusters, they're not contractors, they're not licensed, they don't have the requisite knowledge to determine what needs to be done to put a loss into its pre-loss condition, which is what the policyholder is entitled to. And as a result of that, there can be problems when it comes to either a denied claim or being sufficiently paid for a claim. And fortunately in California, there are laws, there is a regulation that specifically addresses this question. So when a claim is filed under the California Code of Regulations, Title 10, Section 2695.7, it states that if a claim is denied in whole or in part, the insurer has to provide the factual and legal basis for the denial of that claim. And the reason why this is so important, the reason why that part is so important, is because without being provided that factual or legal basis, there's no way to understand, you know, if what insurance is doing is appropriate. So this is important. If there's ever a question, if a claim is ever denied in whole or in part, those questions need to be asked of the insurance company. A good example of this is if you have a water damage claim, if a policyholder has a water damage claim. That insurance company may say, hey, this water damage is due to a long-term leak, and our policy excludes long-term leaks from the policy. Well, that's not sufficient. We need to know the factual reason why that leak was considered long-term. And legally, we need to understand what in the policy itself defines what a long-term leak is. The combination of those things provides the policyholder with sufficient knowledge as to why that claim was denied. Now, this is also important in regards to the legal basis of claims. And there was a case, and it's White versus Western Insurance Company. And I'm going to read this directly from what the holding was of the California Supreme Court, because this is really important for the legal basis. Any ambiguity or uncertainty in an insurance policy is to be resolved against the insurer. And if semantically possible, the contract will be given such construction as will fairly achieve its object of providing indemnity for the loss of which the insurance relates. The purpose of this canon of construction is to protect the policyholder's reasonable expectations of coverage in a situation in which the insurer, draftsman, controls the language of the policy. Whereas coverage clauses are interpreted broadly as to afford the greatest possible protection to the insured, exclusionary clauses are interpreted narrowly against the insurer. These laws were set to benefit policyholders, to protect policyholders, and these laws are on your side.